welcome to this explainer. Today, we're cutting right through the sensational true crime headlines. We are going to look straight at the legal mechanics of how a plea deal actually works, specifically focusing on a high-profile case that's making absolute waves right now. But we're doing it strictly by the book, looking exclusively at the procedural steps and statutory rules that actually define our justice system. Did Courtney Clenney actually plead guilty to murder? You've probably seen that question dominating your feeds regarding the tragic April 2022 death of Christian Obumseli. Well, when a massive story like this breaks, the media tends to fast-forward the timeline, right? They make it sound like a done deal the absolute second a lawyer opens their mouth. But to understand the truth of where this case stands right now, we have to look strictly at the court record, not social media.
And here's the reality. As of our cutoff date for this briefing, August 7th, 2026, the legally verified answer is a hard no. The current, accurate status of this case is simply agreement reported. Despite what the internet might claim, the legal system requires way more than just a lawyer's public statement to finalize a conviction. There is a huge fundamental difference between a negotiated disposition and a final, binding judgment.
So here is our roadmap for today. First, we'll parse out the headlines versus the legal reality, then review the pending murder charge. After that, we're getting right into the weeds of Florida Rule 3.172, which is essentially the star of the show today. Finally, we'll touch on victims' rights in court, and I'll leave you with a solid verification checklist.
All right, let's jump straight into Section 1, Headlines versus Legal Reality. We really need to separate the public file from the actual court file here.
To truly get a grip on this case, we have to isolate the press rhetoric from the hard legal record. This is a totally foundational concept if you want to follow criminal proceedings accurately. Let's look at what was actually said. Late in July 2026, Courtney Clenney's defense attorneys, the Prieto law firm, released a statement to outlets like NBC and CBS. They confirmed a plea agreement had been reached. But listen closely, because this statement contains a massive legal caveat at the very end that almost every headline completely glossed over. They said, "The terms of the agreement are not final until accepted by the court."
And honestly, this brilliantly illustrates the jury chess principle, separating the public file from the court file. A reported negotiation, that lives entirely in the public file. Lawyers can announce an agreement all day long, but until a judge officially accepts it on the record, it hasn't transformed into a true court-entered judgment. Right now, this case is stuck firmly in that public file phase of the agreement.
Moving on to Section 2, the pending murder charge and what the state actually alleged.
Before we can even really process this reported plea, we need to briefly ground ourselves in the foundational legal facts established right after Christian Obumseli's death inside the Miami apartment he shared with Clenney back in 2022. Following her arrest that August, she was charged in Miami-Dade County with second-degree murder and originally entered a not guilty plea. You likely know the arguments. The state characterized Obumseli as a victim of domestic violence, while the defense claimed Clenney acted in self-defense against abuse. But here is the thing. It is vital to remember that these opposing claims are exactly that. They are pending claims in a charged status. They are not established judicial findings.
Just notice how precisely Florida Statute Chapter 782.04 defines the pending first-degree felony charge at the center of this case. The really key language here hinges on acts that are imminently dangerous to another and evincing a depraved mind regardless of human life. Crucially, it notes this all occurs without premeditated design. That right there is the exact legal threshold prosecutors originally set out to prove.
But as we shift from a pending trial to this newly reported plea deal, we hit a massive information gap. Because the agreement isn't finalized yet, we have three essential variables that remain totally unestablished in the public record we're using for this briefing. Literally, we do not officially know the exact offense she is going to plead to, whether it'll be a guilty plea or a no-contest plea, or what specific sentence the judge will ultimately hand down.
Which perfectly brings us to Section 3, inside Florida Rule 3.172. This is the exact mechanism of judicial acceptance we've been talking about. This rule is the absolute core mechanism governing the August 10, 2026 hearing before Judge Andrea Ricker-Wolfson. This is how the legal system actually works under the hood. Right now, the status court acceptance pending reflects a sort of procedural waiting room where the Clenney case currently sits. The agreement is frozen in time until the judge executes her statutory duties, because the deal between prosecutors and defense attorneys is really just a proposal until the court meticulously vets it.
And under the hood, Florida Rule of Criminal Procedure 3.172 is incredibly strict. Before any lawyer-announced deal becomes legally validated, a judge has to check off these very rigid steps. They must determine that the plea is completely voluntary, ensure there is a solid factual basis for the plea presented by the state, conduct the entire proceeding in open court, and make absolutely certain the defendant understands the charges, the possible punishment, and is knowingly giving up her constitutional trial rights.
So, I really want to emphasize this crucial point. While an accepted plea under Rule 3.172 establishes a conviction for a specific offense and avoids a jury trial, it absolutely does not magically turn every unproven internet rumor into a judicial finding. No way. It does not automatically validate every single police assertion or defense filing made over the last 4 years. The exact factual proffer read out loud in court is the only thing that becomes the established record.
Okay, moving to Section 4, Victims' Rights in Court. Let's talk about the human harm in the legal process.
Because while the mechanics of a plea deal are, highly technical and bound by strict rules like 3.172, Florida law ensures that legal efficiency doesn't just erase the victim from the process. The human element remains totally central to the proceedings. The attorney representing Christian Obumseli's family recently released a statement confirming their expectation of a guilty plea. They pointed out that this resolution avoids an unnecessary trial and that accepting full responsibility is a much-needed step toward bringing closure to a profoundly tragic event for their family.
The statutory and constitutional rights in Florida guarantee that the August 10th hearing is not just some dry transaction between lawyers. It's a formal stage to acknowledge the real-world harm. The family has the absolute right to be informed, to be physically present in Judge Wolfson's courtroom, and crucially, to submit statements or be heard before any sentence is formally imposed.
Finally, we've reached Section 5, the final verification checklist. Here's how to analyze the outcome like a true legal insider.
To wrap up this explainer, I really want to equip you with the tools to look straight past the media spin when the hearing actually takes place. You don't have to guess what happens next. You just have to know what to look for. By tracing these strict status labels, we can accurately track the case's entire journey from accusation to the brink of judicial resolution. It started with being charged in August 2022, moved to an agreement reported in late July 2026, and sits today at court acceptance pending.
So, you should use these 5 critical questions to verify the actual court record. Don't just rely on the first tweet you see. Wait to find out what exact count was resolved. Was it a guilty plea or a no-contest plea? Did Judge Wolfson expressly accept the plea on the record? What exact sentence, including credit for time served, was handed down? And did Christian Obumseli's family speak? Answering these ensures you don't surrender your judgment to the loudest, flashiest headline.
As of our cutoff date, this is the definitive, objective limit of what the law has actually established as fact. Everything else is simply a proposal waiting for the rigorous tests of the courtroom.
So I'll leave you with this final thought. When the gavel falls on August 10th, will the court file finally match the public file? And what specific trial rights will be waived to make it happen? I highly encourage you to watch the actual hearing outcome through this newly acquired procedural lens to see exactly how the law unfolds under Florida Rule 3.172. When that gavel falls, you'll be ready to read the actual record, not just the rhetoric. Thanks for joining me for this explainer, and keep questioning what you read.